In this class, we will discuss about directive principles of state policy in polity, one of the chapters. Directive principles of state policy (DPSP). It is mentioned in part 4 of the Constitution, Articles 36 to 51 of the Constitution. These are mentioned in Articles 36 to 51 of the Constitution, part 4 of the Constitution. This is very important. These we have borrowed from Ireland, borrowed from Irish Constitution, and Ireland borrowed from Spain. So these directive principles, these are ideals that state must should keep with it, should keep in mind while formulating policies, while formulating policies and any laws are enacted. So it is a guide, friend, philosopher to executive and legislature, to executive and legislature. These are directives, these are directions to the state. You do like this, you do like that. To the executive, to the legislature. Legislature means which makes the law, executive which implements the law. State, we know, government of India, government of concerned states, or any local authority also, it will come under government. So what is the objective? What is the objective of DPSP? Is to establish welfare state. To establish welfare state. To establish welfare state. So we will see the articles there, you will understand. So some quotes, remember. So Dr. B.R. Ambedkar has called DPSP as novel features of the Constitution. They are novel, means new feature. They are like unique features of the Constitution. Whereas Grenville Austin described them as, of course, fundamental right, DPSP. They together are conscience of the Constitution. They together are conscience of the Constitution. That is Grenville Austin. And M.C. Chagla, former CJ, he called DPSP as, if DPSP implemented truly or properly, India will be heaven on the earth. That is the greatness of DPSP. It is like India will become like heaven. It is that good. The people will be very happy if you truly implement the directive principles of state policy. Then MC Setalwad is a first law commission chairman, also attorney general. He said they are beacons of light to the court, beacons of light to court, means the courts can use them in giving judgment, etc. Then one case, remember, in Minerva Mills case, Supreme Court has said there should be the harmonious construction doctrine, that is balance FR and DPSP. They are two wheels of the same vehicle, you can say two wheels of the car. You have to balance that one. That is given Supreme Court in Minerva Mills case. You cannot say one is more, one is that. You have to take balance. That is clearly said by the Supreme Court in Minerva Mills case. If you take first, you take articles, then you will understand the nature of the directive principles. So first, what 36 will say, it defines the state. What is state? Okay, same as in part 3. Okay, here state means central government, state government, etc. will come. Then 37, it says DPSP, whatever these directives should be, are non-justiciable. That is not enforceable in court of law. They are not enforceable in court of law. That is the first one. Second one, however, they are fundamental. Yet they are fundamental in the governance of the country. Governance means ruling of the country. Then it also says state must apply them, must apply while making laws. So one side it is DPSP are non-justiciable. For example, if you cannot go to court in case of violation of the DPSP, yet they are fundamental in the governance of the country, and a state must apply while making the law. So while when state is ruling, the DPSP should be kept in mind while framing the law, while implementing the law. That is the 37, Article 37, application of directive principles. Then 38, state should promote social order so that it will become the welfare of the state. You promote social order so that welfare of the state is achieved. Welfare of state is welfare of state is achieved. This article says, so Article 38 one says you promote the social order so to achieve welfare of state. Welfare of state. That is one thing. To achieve welfare of state, also that you have to achieve the justice, which is social, economic, and political. This is also mentioned here only. Justice, social, economic, and political. Then 38 2, you have to reduce inequalities in income. You have to reduce it and eliminate inequalities in status, facilities, opportunities. This is what is given in Article 38 Class 2. Article 38 Class 2. Then Article 39 says certain principles to be followed by the state. These are directions to the state. So, what are those principles the state must follow? That we will see now. Here 39A, it adequate means of livelihood should be provided. Adequate means of livelihood should be provided for both men and women. For both men and women. Adequate means of livelihood. So, example you can take there is Manrega Act, MG Narega Act, MG Narega scheme. This is 100 days employment is guaranteed. 100 days employment guaranteed. Then 39B, material resources should be distributed so that it is benefited to all. It distributed to benefit all. In 39C, there should not be any concentration of wealth. There should not be any concentration of wealth. 39D, equal pay for both men and women. 39E, health of workers, tender age of children, health of the workers, both men and women, tender age of children, and citizens not be forced by economic necessity to enter vocations, means jobs not suited to them. Like you are giving, say, for child some in factory, some hazardous employment. That should not be done. Then 39F, children should be given, they should be given some freedom and dignified life. They also, you have to, childhood and the youth should be protected. Childhood and the youth should be protected against exploitation. Exploitation means misuse. Example, child labor. You should not employ children. You have to provide good education, good food, good health to them. That is the basic necessity of the state. So this is certain principles to be followed by the state. However, if you take this 39th constitutional, this 39F, this is has come from 42nd Constitutional Amendment Act 1972. Sorry, 1976. 1976. That is there. And here 38 too. This is added. Okay. This is added through 38 na 8 you make off. So 44th Constitutional Amendment Act 1978. 1978. 44th Constitutional Amendment Act 1978. Then we come to 40, Article 40. Here 39A is there. Free legal aid. Okay. Free legal aid. For example, There is an also National Legal Services Authority, okay, where it will support, okay, to give for legal aid. Let's say who are there is no support, so you can get support from them also, who are you are very poor but you have to fight the case, then it will provide free lawyer, and that facility is available. That is, state has to necessarily provide the legal aid, and have to promote the justice of the promote justice, legal aid, and we have to promote justice. Then article 40, organization of village panchayats. Village panchayats, so this has been realized by 73rd Constitutional Amendment Act 1992 and 74th Constitutional Amendment Act 1992. 73rd and 74th Constitutional Amendment Act 1992. So from here panchayats here, and here municipalities has come. Here panchayats has come. 73rd and 74th Constitutional Amendment Act, that is 41. Means from here you can observe one thing, that these directive principles are not enforceable by themselves. You need law. So state has to create law. We have seen there is Manrega Act, there is 100 days employment, there is Manrega Act 2005, Mahatma Gandhi National Rural Employment Guarantee Act. And then if for example rural local government, there is 73rd Amendment, 74th Amendment to the Constitution. So there is a law. Similarly, if you take 41, there is a right to work, right to assistance, okay, you have to provide some assistance, etc. In some cases, in some cases you have to provide some assistance, okay, when unemployment is there, okay, and then old age is there, then sickness is there, then disablement is there. In these cases also, there is you have to provide the work and assistance, some work and assistance you have to provide. So for to deal with employment, there is Mahatma Gandhi National Rural Employment Guarantee Act, okay, Guarantee Act 2005. This is providing the 100 days employment in rural areas. In rural areas, this is what, to fight the unemployment. For old age, yes, there is pensions through various act it is giving. For sickness, yes, some facility is there. For example, you take some TB patient, etc. For here PWD act is there. So some benefit, some provision, some help is giving state through various laws it is creating. Okay. And these laws are inspired from the directive principles of state policy, that is DPSP, taken from part 4 of the Constitution, Article 36 to 51. Then Article 42, just and human work plus maternity relief you have to give. There is Maternity Benefit Act, Maternity Benefit Act. So where, for example, if you are a salaried employee or otherwise also your government, okay, government salaried employee, you are giving leave, for example, paid leave. That is paid leave you are giving. That is under maternity relief it is provided. Also, there is Pradhan Mantri Matru Vandana Yojana. Some scheme is there. Okay, some around some 5,000 is providing by the government to the mothers, to the new mothers. And then you have to provide just and human work. Yes, some various laws are there, Industries Act, where you have to provide safe conditions to the workers. So that is what state saying directive principles are directing the state, and the state is taking various steps, various acts to implement them. Then you take 43. 43 living, you have to provide living wage, you have to provide work, you have to provide decent uh, standard of living, Okay, you have to provide leisure, and you have to provide socio-cultural opportunities. Okay, and apart from this, you have to also promote the cottage industries. Cottage industries means small industries. So you have to promote the cottage industries, okay, on individual basis or on cooperative basis. This is the Gandhian principle. This is the Gandhian DPSP. This is the Gandhian DPSP. This is the socialistic. It is the entire society community. It is targeting living wage, good decent living, good leisure you have to provide. For example, good lunch break. There are some workers where they are given hardly given any lunch break, or very less time for the lunch break. So that should not be there. You have to provide good leisure to them, good opportunity, socio-cultural means like some kind of enjoyment. You have to provide, not simply you have to extract the work. Like Britishers, you should not simply exploit them. You have to provide these things, good wage, good amount for their work you have to provide. And then cottage industries, that is there. Then 43A, 43A says participation of workers in management of industries. Participation of workers in management of industries. So this is has been added through 42nd Constitutional Amendment Act. Then 43B, cooperative society. This has been added through 97th Constitutional Amendment Act 2011. So if you take 97th Constitutional Amendment 2011, cooperative societies added. Cooperative societies. So there is 19 C law, one word added. Okay, added cooperative society. Then 43B, yes, about cooperative society. Then part 9B is about cooperative societies. This and all 97th Constitutional Amendment Act. This is important, very important. You have to remember. So 43B, it is about the cooperative society. You have to, this is voluntary formation, autonomous functioning, democratic control, and professional management. These are the things, okay? Voluntary formation, autonomous functioning, democratic control. These are the things it provided in 43, Article 43B. Next, Article 44, you may be knowing, very famous article in recent, very news. In recent times, it was in news. Article 44 about Uniform Civil Code. So let's say there is two codes actually, one criminal code, one civil code. Criminal code, we know the same criminal law will apply to everyone. Let's say you are whether Hindu, Christian, or Muslim, whatever, the same criminal IPC Act will apply to you, all people, irrespective of the religion. But the civil code is not like that. Civil code actually deals with marriage, okay, then divorce, okay, any land settlement, okay, or property, whatever, land property. So these things are dealt by the civil act. But this is something different for different religions. Different for different religions. Different for different religions. For example, there is Hindu Marriage Act for Hindus. Similarly, for Muslim women protection of laws, there is for Muslim separate act. So different religions have different. So there is no single code for in India with respect to civil offences or civil disputes to solve that one. That is given in Article 44. As of now, we don't have uniform civil code, and even our Prime Minister also in various Independence Day speech also he our honorable Prime Minister spoke of this uniform civil code. Then Article 45, you have to give early childhood care and education. Okay, up to 6 years age. This is given. This is has come from 86th Constitutional Amendment Act 2002. Then Article 46, educational and economic interests. Okay, educational and economic interests of weaker sections. Okay, you can say SC, ST and backward classes. Then Article 47, raise the nutrition and the standard of living plus improve the health. Plus you should stop intoxicating drinks or intoxicating drinks except for medicinal purposes. Except for medicinal use. This is what Article 47 says. This is what Article 47 says. So this drink alcohol, etc. You should not. This is Gandhian principle. This is Gandhian principle. Then Article 48, agriculture plus animal husbandry. You have to do on scientific, modern and scientific lines. Plus at the same time, plus you have to slaughter of cows, etc. You have to cows ban. Okay, ban as per Article 48. As per Article 48. Then Article 48A. Article, just a minute. Article 48A, protection and improvement of forest, of environment, safeguard forest and wildlife. That is 48A. This has been amended through 42nd Constitutional Amendment Act 1976. Then Article 49. So you have to protect the monuments, also places and objects of national importance. Then Article 50, separation of judiciary and the executive from the executive. Then Article 51A says there should be peace. You have to fight for international peace. Then there should be good relations between states. You have to maintain. Then C, international law or treaty you have to respect. Then D, any dispute or settlement you settle by arbitration. Settlement or any dispute. This is international peace. Okay, between countries. International treaty. So here there should be fight for peace. There should be good relations should be maintained between, and law you have to respect. And then there is arbitration. You have to encourage to settle the dispute. between any countries they are coming. So these are the important articles, and here you have to remember one thing. Article 44, 45. 44 Uniform Civil Code, 45 Early Childhood Care Education, then 48 Agriculture plus Animal Husbandry, and there should be ban on the cow slaughter, that is 48. Then 49, 50, 51. Okay. Then 48A also, environment. You have to safeguard the environment, forest and wildlife. So except this one, okay, except this one, remaining all we call intellectual, liberal intellectual, liberal intellectual, DPSP. This is the classification of DPSP, liberal intellectual DPSP. That is one thing. That is one thing. And then you take Article 38. It is promoting what? Welfare state. Welfare state. Then 39. Certain principles that a state should follow. 39A. Free legal aid. 39. Okay, free legal aid. 39A. Then 40. 40 village panchayats. So here I am putting Gandhian DPSP. So Gandhi has Mahatma Gandhiji has always fought for village democracy. Then 41, so right to work and assistance. Okay, when unemployment, old age, sickness and disablement or any undeserved want. Then 42 is there. Then 42 is there. You have to just and humane work plus maternity relief. Maternity relief. Then 43, we have two things. It's actually here cottage industries is there. This here it will not come. So here 43 cottage industry will come here. Then 42, 43. Then 43A also here only will come. 43A. Just let me upside. 43A participation in the management of industries. Then 43B here it will come. Cooperative society. Mahatma Gandhiji was fighting for that 43B also. Then 44 here I put 44 in liberal intellectual uniform civil code. Then 45 also liberal intellectual. Here I will rewrite 44, 45. Then 46 again weaker sections helping Gandhiji again is fought for that during independence. Then 47 nutrition. Okay, 47 there is nutrition plus living, standard of living. These two is there, plus there is also drinks. You should not drink. This will come here. 47 drinks part. Then 48 agriculture plus animal husbandry will come. 48A environment, forest, wildlife here it will come. Then 49, 50, 51. So these are classification of the DPSP. In some exams they will ask which of the following is the Gandhian DPSP or which of the following is the liberal intellectual DPSP. Then you have to remember this classification. This is important. Then now come to, and you remember the amendments also, constitutional amendments actually. So constitutional amendments, there are Hardly four. There is 42nd Constitutional Amendment, 44th, then 97th, then 86th also there. 86th, 97th, 97th 43B, 86th 45, 44 38 class 2, and this is rest. Rest means you can say 39F, 43A, 43B, no, 48A, 43A, 48A, and any other it will come. It will cover in this only. It will cover in this only. 43A, 48A, 39F, 43A. Sarah anything 38, 39, 39A, 43, 43AB, 44, 45, and 46. Not no amendment. 47. So yeah, these amendments. Remember, these are the new directives, new DPSP brought through constitutional amendment. This you remember. Now you come to features of the DPSP. From here only you will understand that they are non-justiciable, given in Article 37, yet fundamental in the governance of the country. Fundamental. They are yet fundamental in governance of the country. Where it is given again Article 37. And the state should apply them. State should apply when making policies, laws, etc. And it will provide for the welfare state. Okay, during British time we have police state where police were controlling everything. If anything, for example, riot is there or farmer is there, he is not paying tax, for example, then police will come into the picture. So, like that, police state, it is discipline is brought into the people by the policing, not by helping the people or not by improving their things, improving the society or community, whatever. So it is a welfare state. DPSP is going for welfare state. It is a for socio-economic development. Socio-economic development, or we can say socio-economic justice. Socio-economic justice. Okay, there is justice, social, economic, political. It is given in Article 38, Clause 1. So this welfare state concept given Article 38. This is given in Article 38. So they are non-justiciable, still they are fundamental in the governance of the country, and the state should apply them when making policies and laws. And DPSP will establish fight for the welfare state against the British policy, which is they were trying for police state, and it will fight for socio and economic development, socio-economic justice. Also, there is one more word where we use socio-economic democracy. Socio-economic democracy. Okay, where fundamental rights will give political democracy. And then we have inspired, there is Government of India Act 1935, Instrument of Instructions. Instrument of Instructions. Okay, Instrument of Instructions. From here, the DPSP has been inspired. To some extent, we have they are similar to the Instrument of Instructions. From there, we have taken, and then help courts in judgment, in deciding their for example, Supreme Courts or High Court can uphold laws if give effect to DPSP. Let's say I have created a maternity benefit act. Maternity benefit act, maternity benefit, it will not give good example. Let's say I am implementing 39 BC, okay, where you have to material resources, okay, and concentration of wealth. There should not be concentration of wealth, and material resources should be divided. So for this, let's say I am abolishing the Jamindari system. Jamindari system means where one person will have hundreds and hundreds of acres of land with him. That is what Jamindari system. This came during the Mughal, and then later continued during the British period. This Jamindari system holding lots of land by one person. So to implement this, I am, let's say, 39B or C, to implement this DPSP, I am going for abolition of Jamindari system. Now court can refer 39BC because it is helping the people. So I will uphold the abolition of Jamindari system. Let's say Jamindari system I am cancelling. Let's say I am Jamindari system now gone. So now what is happening exactly? Some people, there is fundamental rights also. So some people, there is fundamental rights. There is article 31, right to property, earlier was there. So now these people are going to the Supreme Court. Okay, so there is Supreme Court, and there is one Jamindar, and there is a state. So what state is saying? I am implementing DPSP. What Jamindar is saying? My fundamental right got violated, article 31. So now Supreme Court entered and checked, yes, okay, it is implementing DPSP. So I will uphold the abolition of Jamindari. So this manner there is a complete, it will help the courts to arrive at a decision which will give effect to the DPSP. So these are the features of the DPSP. These are features of the DPSP. These are non-justiciable. You cannot go to court in case of violation of DPSP. Whereas fundamental rights are justiciable. Even fundamental duties non-justiciable. So yet DPSP are fundamental in the governance of the country and should apply when making laws or any policies or programs. And DPSP will lead to welfare state. It will go for social development, economic development, or socio-economic justice, and social economic democracy is achieved from DPSP. Then Government of India Act 1935, it is similar to instrument of instructions as mentioned in Government of India Act 1935. They are kind of instructions to the state. You do this to help the people, and also it will help courts. It is help courts. So that's why MC Setalwal says it is a beacon of light to the courts. It will serve as lighthouse to the courts. It will give some direction to the courts. That is article features of the DPSP. And then classification I given already. Classification, three types I given: socialistic, okay, Gandhian, liberal, intellectual. Liberal, intellectual, this I given. And then new directives we have seen. There is 42nd, 44th Constitutional Amendment Act, and then 86th, then 97th Constitutional Amendments. New directives like that it has come. Then if you take sanction behind DPSP, sanction means why we have included a sanction behind DPSP. Sanction behind DPSP, there is some gray area where you need some patience to listen carefully. So if you take Sir B.N. Rao, he is the main person who fought for the DPSP inclusion or proposed the DPSP. So he initially, actually what happened, if you take the history, initially there is Karachi resolution, Karachi resolution in 1931. Okay, here first time INC has raised for the social economic justice issue where wage, okay, good work, etc. to the people in Karachi resolution. First time it brought into the INC where we have to help the people, whether it is peasants, whatever. Then slowly in 1920s there were labor and peasant movements, labor and peasant movements. This also has given some kind of relief we have to give to the labor and peasant movement. This also inspired the DPSP to the Constituent Assembly members who also many freedom fighters led these labor and peasant movements. Then finally, there is SKri committee. SKri committee in 1945 it has recommended for two rights. Okay, one is justiciable rights, means you can go to court in case of violation. Another one is non-justiciable rights, that is you cannot go to the court. So from here the Constituent Assembly has been inspired, and then there is a subcommittee on subcommittee, rights subcommittee, okay, or fundamental rights, whatever. Rights subcommittee is there, and this committee has accepted this division. Accepted, okay, there are some rights which are justiciable, some are which are non-justiciable. Okay, and these are came to be known as fundamental rights, this as DPSP. So this is some background for DPSP, how Constituent Assembly members have included this DPSP. Then apart from Sir B.N. Rao, then A.K. Iyer, Lord Krishnasamy Iyer, then Dr. B.R. Ambedkar, then K.T. Shah. So these are the people who mainly debated much to bring this in the Constituent Assembly, to bring the DPSP into our constitution. So actually K.T. Shah has criticized the DPSP. He has criticized these are mere pious aspirations, means they are simply aspirations, they are not as non-enforceable, as non-justiciable, they are simply pious aspirations. He said it is a check, okay, where a bank can pay only when resources permit. It is similar to a check where bank can pay only when resources available. So on check there will be one condition: the bank shall be payable to you only when resources in the bank are available. So like that means the bank can say I don't have resources anytime, it will not pay. So it is DPSP also similar to that, because in case of violation, let's say state is not taking care of this DPSP, then you cannot go to the Supreme Court or High Court, or any for that matter any court you cannot go, because they are non-justiciable. So that's why K.T. Shah, that professor, pious aspirations he termed, and also it is like a bank check where bank can give only when resources are there. However, Dr. Ambedkar ji is having different view. He termed DPSP as novel features of the constitution, and they are similar to instrument of instructions. They are kind of instrument of instructions to the state. Okay, and he also said even you cannot ignore the DPSP, because you have to answer at least in the court of people, that is during elections. Okay, let's say you are not implementing any DPSP. Let's say you are not giving early childhood care and education. You are not promoting weaker sections. You are not helping weaker sections. Then I may not go to court, but definitely elections will come. Then people will definitely not vote to that government or that party. So that is the court of people. Okay, you cannot go to court of law, but you can do court of people is there, where people can ultimately defy the government and it can bring the new government. So these are the people and these are the terms you remember. Then the main very important thing is difference between FR and DPSP. FR and DPSP. So difference between the FR and DPSP. So these are negative in nature. Negative in nature. These are positive. Positive obligation. Means state has to do that. Okay. Here state has to do. For example, state has to implement some laws. But here state should not do. For example, no discrimination. State should not discriminate. State should not discriminate. Okay, here positive application means here state should promote welfare. Okay, should promote. Here there is no, this is the positive obligation. This is the positive obligation. This is the negative obligation. So that is the first important difference. And then second thing, these are justiciable. These are non-justiciable. Means you cannot go to court. Justice, fundamental rights are just, let's say fundamental rights are violated, then you can directly go to the court. Then it will promote welfare of individual. So these are personalistic. Okay, they are personal or individualistic, where it is a welfare of community. It will promote the welfare of community. Okay, for example, you are improving the health. You are not improving the one person or one individual. You are improving whole community. For example, Maternity Benefit Act. It is applied to the whole woman. It is not applied to the particular woman. It is all community is benefited from here. That is welfare, individual welfare, community welfare. Individual welfare, community welfare. And to implement no separate law is required. Separate law required to enforce. Here separate law is required. Here separate law is required. Law is required. Example, you can say Maternity Benefit Act. Maternity Benefit Act or Wildlife Protection Act. Okay, to implement 48A. Forest Conservation Act to implement 48A. This Maternity Benefit Act, Article 42. So this one, and in case of violation, Supreme Court can strike down that law. Can strike down that law. Okay. Here not so. Supreme Court cannot also, but Supreme Court or High Court, whatever, can uphold a law if that law give effect to DPSP. So let's say fundamental right Article 14 get violated. Let's say you implemented I will give jobs to only this area people. This is against Article 14. Then definitely the Supreme Court will strike down this law. But if DPSP are violated as let's say you have make any law, then DPSP is violated. Then Supreme Court cannot strike down that law. But there is other side. Court can uphold that law if DPSP are implemented, because DPSP are promoting the welfare of the state, promoting the welfare of the people, welfare of the community overall. Maternity Benefit Act, it is promoting whole women. It is to participate in the employment. So it will ultimately empower the women. So in that manner, DPSP are very very important. So if any law that is giving promotion priority to DPSP in Supreme Court, definitely it is the Supreme Court will uphold that law. So this difference you remember is very important. Then significance, by this time I explained significance. Okay, it will promote welfare state, welfare of the people, welfare state, then socio-economic development, Socio-economic development, it will promote socio-economic development. Then political stability will be there. Okay, political stability and continuity. Okay, let's say various governments every 5 years, let's say 5 years, 5 years, 5 years, various governments is coming, government 1, government 2, government 3. So if DPSP are there, they will be like provide some direction. For example, maternity benefit act, it will continue. Keep next government is coming, it is not striking that. It will keep continue. That political stability will be given, and also they are supplementary. They are supplementary to fundamental rights are there. Fundamental rights are there, and they will actually complement fundamental rights. Okay, complement fundamental rights, meaning fundamental rights are giving you individual rights. For example, Article 22 says the police cannot simply come and arrest you. Article 21 says right to life. For example, one army man is there, he will always holding a gun. He cannot simply fire at you. Okay, because right to life, Article 21 guarantees right to life in India. So if you have only individual rights, it is not sufficient. There should be the community rights also. There should be the whole community. There should be some rights. Society as society as a whole, it should be developed. Then only you can enjoy the fundamental rights. Let's say state is not giving maternity benefit act. Okay, then it is definitely a problem. The women may not participate because maternity benefit act definitely should be there, because when pregnancy is there, they may not attend the office. You should give them leave at that time. So DPSP are complementing the individual rights or fundamental rights, that you should keep in touch. Then it will act as a tool to opposition to question government. You are not ruling well. You are not brought this law. You are not promoting weaker sections. You are not implementing UCC Uniform Civil Code Article 44. You brought DPSP Article 40 village panchayats. Okay, but some other DPSP is not implemented. So like that, it will also during voting politics and all, it will act as a common political manifesto. It will act as common political manifesto. So, and some quotes you remember, I told already. Okay, Ambedkar call them as novel features and instrument of instructions, and they have to court of people is there if not implemented. Okay. Then MC Chagla, it will be heaven on the earth if implemented properly. Then MC Setalwad, beacon of light. To courts, it will serve as beacon of light to the courts. It will serve as beacon of light. Then Grenville Astin, fundamental rights plus DPSP as a conscience of the constitution. Conscience, Antaratma. Conscience of the constitution. So these quotes, and one criticism is there that K.T. Shawala, you remember? He said these are mere pious aspirations, and it is simply aspirations. These are not enforceable courts by courts. It is non-justiciable. So it is like a check on a bank, payable only when the resource of the bank, only when bank is having the money. So that is one thing. And also there are some other criticisms like it is illogically arranged. And illogical means some important and unimportant DPSP are mixed, so there is no proper arrangement is there. That is what criticized by some political analysts. And then they are conservative, okay, like not suited to 21st century India. They are somewhat outdated, like that some has been considered. And then there is a constitutional conflict Okay, between state and center. Okay, then between PM and president, there is some dispute has been come because of this DPSP. State versus center. How, for example, center is saying to state, you implement this DPSP. When state is not implementing, this center can overtake the state machinery. Under Article 356, Article 356 President rule, or Article 356 or Article 365. If Article 365 says if state will not follow the whatever center is saying, okay, then the center can overtake the state. That is given. PM versus president. Let's say PM has brought the bill that violates DPSP. Okay, that violates that. Then president may not sign. He may say that it is violating the DPSP. Okay, so some kind of constitutional conflict it may arise because of this DPSP. That is what some people have been intended. Then conflict between FR and DPSP. So here first one, here Champakam Dorai Rajan case. Okay, Champakam Dorai Rajan case. Dorai Rajan case. Here FR is greater than DPSP, the court said. However, Parliament can amend fundamental rights. Okay. So when then first Constitutional Amendment Act 1951 has brought. So which said which amended the fundamental rights. For example, 15.4 has put Article 15.4, then Article 19.1G occupation. Okay, for example, Jamindar abolition has done. Then 9th schedule. Okay, for land reforms. So all these, what is happening? Right to property get violated. Right to property getting violated. So this is what center has done or parliament has done that time. So then what happens? Then again people are going to the court like Jamindars and all because their right to property has violated. Then Golaknath case is there 1967. Very important. Here Supreme Court said cannot amend fundamental rights. So Supreme Court even said no power under Article 368 to Parliament to amend the Constitution. This is a big statement actually. So under Article 368 there is no power to you at all, Parliament. How can you amend the Constitution? Even fundamental right, which is sacrosanct. Fundamental rights are considered as sacrosanct. You cannot amend simply like that. They are very powerful. You cannot touch the part 3, fundamental right. So Golagnath case 1967 it has come. So immediately Parliament responded by amending the Constitution, 24th Constitutional Amendment Act 1971. It amended the Article 368, added the word power. Add the word power. Now I have power. So let's see, Mr. Supreme Court. Now I have Honorable Supreme Court. Let's see. I have power. Added the power word. Now I have power. Now I can amend the Constitution. Then again immediately. Then 25th Constitutional Amendment Act 1971. It added Article 31C to the Constitution. Article 31C, which says 39BC, that is DPSP, is much greater than Article 14.19.31. This is what Article 31C says. Here, DPSP is greater than FR. This is what it is saying. So, fundamental rights got violated. So, then people went to the Supreme Court. Then the third case, very important, KBC Keshwanand Bharati case 1973. Here people went, here said, okay, amend. Fundamental rights can be amended. Can be amended. Okay, center, you, okay, parliament, you please amend. But parliament, you, but see, okay, but basic structure cannot be changed. Basic structure of the constitution you cannot change. This is what the doctrine of basic structure has evolved. Doctrine of doctrine of basic structure. Doctrine of basic structure is came from here, Keshwanand Bharati case. So here in 31C also it said no judicial review, no judicial review. So it struck down the judicial review part of the of Article 31C. So Article 31C, it is having two provisions, 39BC, DPSP greater than Article 14, 1931. Also 39C says no court can enter. That is, judicial review is not there. Judicial review means court cannot interfere into this article. Then Keshwanand Bharati case, Supreme Court said, no, I will interfere. Judicial review. No, it is a basic judicial review. It is a main part of the constitution. This you cannot say. Courts cannot interfere. This you cannot say. So this part of the judicial review, this part of the Article 31 has been removed by this Keshwanand Bharati case. Then ultimately, in Minerva Mills case, 1980, Minerva Mills case 1980, what happens? Here, FR and DPSP, you should balance. There should be doctrine of harmonious construction. Harmonious construction. That is, you have to balance both. You cannot say one is more, one is high. Okay, these two are two wheels of the same car. Two wheels of the same car. Okay, you cannot go with one wheel, na? You cannot drive the car with one wheel. This is what it says. Further, in between, what happens here, in between 42nd Constitutional Amendment Act 1976 has amended the Article 31C. It says any DPSP, not 39BC, not only 39BC, is now greater than Article 14, 1931. So this has been in Minerva Mills case. This has been amended, and it says 39BC is only greater than Article 14, 19 and 31. And we know 44th Constitutional Amendment Act removed Article 31, also Article 19(1)(f). This is related to right to property. And it has put under Article 300A, right to property. Under Article 300A. So this, like this, so ultimately what is the present position? 39BC is greater than Article 14 and 19 only. So now 31 also gone. So this is the conflict how it has been arised between the FR and DPSP over a period, and finally there should be doctrine of harmonious construction or balance should be there between FR and DPSP. This is what Supreme Court iterated many times. Then I told to implementation of DPSP. Implementation of DPSP. Next, implementation of DPSP, you have to make acts. You have to make acts. Many examples I given in the above lecture. And then directives outside part 4. So there are only 3 directives. One is Article 335, SC/ST claims. In central government or state government services. That is jobs. The deficiency should not be undermined. That is there. Then Article 350A, then instruction should be in mother tongue. Okay, every state or local authority should see who is linguistic minority. Okay, and you have to in primary school you have to give instruction in the mother tongue. This is Article 350A, and then Article 351. Okay, center or union to directive to union to promote Hindi. That is Article 351. So these are the directive principles of state policy. Part 4, Article 36 to 51. Explained in detail. You can go through this one. So I will simply brief it. I will not go in detail. Directive principles of state policy, part 4, Article 36 to 51. These are borrowed from Ireland. This is important. This borrowed from Ireland. These are directives to the state, means legislature, executive. This should follow, and this will also help the judiciary acts as a beacon of light to giving while deciding the judgments. And what is the main objective? It is promote as a welfare state against the police state, which was in during British era or British time. So various people has called, for example, novel features by Ambedkar, concerns of the Constitution, Colonel Austin. It will be like heaven on the earth if you truly implement DPSP. MC Chakla, MC Setalwat says beacons of light to the court. In Minerva Mills case, you should balance both FR and DPSP. That is what Supreme Court reiterated. And then Articles 36 to 51 I explained along with the amendments and along with the classification that which fall under socialistic DPSP, which fall under Gandhian DPSP, or with the, which are liberal intellectual principles. These are the things along with the amendments and classification you have to remember. Then features I have discussed, these are non-justiciable yet fundamental in the governance of the country, and state should apply when making policies or laws. This is as per Article 37. Then Article 38, it is giving welfare state. There is socio-economic development. Then Government of India Act, there is instrument of instructions similar to the DPSPR. Then it will also help the courts in deciding judgment. Then sanction behind means there is some background. If you take Karachi resolution, then labor peasant movements, then Sabru committee 1945, then Constituent Assembly rights subcommittee is there of Constituent Assembly that accepted finally which are justiciable rights. They are categorized as fundamental rights, non-justiciable rights as DPSP. Then 4 people, Ben Rao, A.K. Iyer, Ambedkar and K.T. Shah. These people fought, debated heavily in Constituent Assembly for the incorporation of this DPSP. Then differences between FR and DPSP, these are again important. Here you can add one more thing, that this promote, here you can add this promote political democracy. Okay, this will promote socio-economic democracy. Socio-economic democracy. And then significance, political stability. Then supplementary to fundamental rights, act as tool to opposition to question government. The common political manifesto, and these some courts. Then conflict, Champakam Thurarajan case, then Golaknath case, then KBC and MMC. Then you have to implement DPS. It means you have to make a law. Unless you make law, you cannot implement. But fundamental rights automatically enforced. No need to make separate law again. Then directives outside the part 4 of the Constitution. Part 4. For example, 335, it is there in part 16. Part 16, it is there in 335. Then these two are in part 17. Part 17 of the Constitution. So these are DPSP. You practice some questions. Previous questions of SSC, UPSC or various exams, NDA, all that. Then you will be getting good command in DPSP. Thank you.